Good morning. Good morning. Gianluca Grossi speaking from Pirola Pennuto Zei from the law firm of Milan. It is my pleasure to present the first thematic webinar of unyer. What is it, unyer? Very shortly. Unyer was founded in 2021. Is a global organization of leading international professional service, which aims to offer to the client the best possible one-stop shop solution under a common international umbrella. How many we are? We are many. unyer counts 2,500 lawyers and professionals, and turnover aggregate turnover of 650 million euro. And unyer offers offices in 10 countries across Europe and Asia. Our goal is to have in under this umbrella the firm, the full service firms, leader in their respective local and domestic markets and area of law, respectively, and to have a law firm which share the same vision and values, to have a compelling industry expertise and focus and advice across all jurisdiction. In general, the goal is to have a global client base. So today we are pleased to present to do a presentation. I want to introduce Christiane Kühn from the law firm Luther in Munich, Benjamin Hub from the law firm Luther in Hamburg, Pierluigi Samarotto, his colleague of mine from the law firm Pirola Pennuto Zei in Milan. And very likely we'll be joining Sarah Poplar from Fidal, France, in a few minutes. She should join the meeting. The subject of today's webinar is direct liability in distressed companies, recent trend in Germany, Italy, and France. We try to stay on this path. What is and when is the insolvency? So what and when the insolvency happens in the different countries. Application for the insolvency, when to file the application, what delay. Third, what might happen to the directors and auditors, types of liability, practical application, and recent trends. Finally, fourth, what should the director remember from this webinar of today in regards to each country. So it's the moment to give the floor to Christian and Benjamin also, so that they can start the presentation.
Thank you very much, Gianluca, for this introduction. I will now start with an overview to the German insolvency reasons that could apply, and afterwards I will hand over to my colleague Benjamin, who will give some more detailed information about the potential liability risks that you might face if one of the insolvency reasons applies for your company. Basically, we have three reasons to file for insolvency. in Germany. The first one is a voluntary reason, which is called the imminent inability to pay. In this case, you have a rather broad focused period of 24 months, and it gives directors the opportunity to start restructuring measures for the company rather on the long term. Yeah, if it's not so urgent, so you can start such proceedings already if you see probably that the company might have a financial difficulty in 1.5 years or the like. So that helps especially to restructure companies. The second insolvency reason is the so-called over-indebtedness. It is a mandatory reason which usually applies, and it exists if the assets do no longer cover the existing liability. It is so therefore basically a balance sheet insolvency. It is not a cash insolvency. It comes up out of the results of the balance sheet, but it applies only, and this is the wording of the law here, unless the continuation of the company is predominantly probable. That means basically that an auditor looks into the figures of the balance sheet and decides whether there's a positive continuation prognosis or not. If the first one is the case, then you're likely not over-indebted and not obliged to file for insolvency. This is the good news. The third and most important reason to file for insolvency is the inability to pay, which is basically the fact that your company is running out of cash. It is a mandatory filing, and 90% of the German cases are based on this insolvency reason. That is, in fact, since this is a major trigger, we want to take a closer look to this insolvency reason here. It basically means that the debtor is not able to fulfill obligations when due. We do an accounting review, yeah, and look what are the receivables and the liabilities today. We check the incoming receivables and liabilities for the next 3 weeks. And basically, if there is a gap which is higher than 10%, there is then, as a consequence, a rule that the company is called unable to pay, which means basically that you are obliged to file for insolvency. And the second kind of having an inability to pay, which is also typical, is the suspension of payments. So if the company has to stop payments because it's just running out of cash, and cash cannot be received on the short term within 3 weeks the latest, then you have the so-called suspension of payments itself. What is important here to know is that in both cases, which means if you have a cap higher than 10%, or if there is a suspension of payments, those facts trigger the burden of proof on your side in case of a later dispute. That means the insolvency administrator who might bring a director's liability claim against you might have here an easier burden of proof, because you have to show it was otherwise. So if you, in this situation, come to the conclusion that one of the insolvency reasons, one of the mandatory reasons does apply, then of course the time is running. And regarding the remaining time frame, it is important to note that after that occurrence of illiquidity, you have just 3 weeks left. And that's, of course, if you have to prepare the filing and as a plan B, prepare some restructuring measures or the like, there is not much time left. And in any case, if you know from the very beginning onwards that there is no room for a restructuring plan, you even must file immediately. So you're not allowed to use that 3 weeks period just for hope or whatever. So it's important to note that it's a maximum deadline that must be considered. And now I want to hand over the presentation to my colleague Benjamin. He will take a closer look to the details of the liability claims that might be triggered if you file too late for insolvency. Thank you.
Yeah, thank you, Christiane. So, if filing requirements have not been complied with, directors can face many legal issues under German law. Personal liability on a director can be established in various scenarios, always depending on the particulars of the individual case. This slide shows only some of the liability-related issues. Most important is the director's liability for delay of insolvency filing, of course, but there are also others. As to delay of insolvency filings, there are basically two sets of cases. One is previous creditors, meaning such creditors who had a claim against a company before insolvency occurred. They will suffer a loss as their entitlement for an insolvency quota, which is a part of the proceeds, reduces as time goes by and the company continues to make losses. These claims, based on a reduction of the insolvency quota, are pursued by the administrator. So the administrator is the one to go after the directors in these cases. Then there are the so-called new creditors who entered into business with the company after insolvency occurred, but before the delayed filing has been made. For instance, the director engages service companies who render services to the company and invoice them only later. If such claims for the services rendered will not be paid anymore before the filing, the creditor may even be directly be sued by the director may even be directly sued by the creditor. So this is a direct claim, which is not pursued by the administrator. Furthermore, directors tend to keep the company running until the last moment. Often they will make payments which are essential for the continuation of the business, such as a payment of utility providers, payments in order to safeguard supply sources, and all kind of payments which a managing director deems necessary, in particular at a point in time where he still tries to restructure the company. So this is an issue of when and to which extent interdiction to make payment kicks in. If the rules on this are violated, the director will be liable towards the company. Also, these claims are collected by the administrator. Another big issue is payments to shareholders, which lead to insolvency. And it should be pointed out that particular attention has to be paid to tax payments and payments to other authorities such as social security contributions, since non-payment can lead to personal liability. But the problem is, in certain cases, such payments cannot be made nevertheless, or may not be made nevertheless, at least not in the full amount. Lastly, in Germany, not filing for insolvency is a criminal offense, as it is in most other jurisdictions as well. But in Germany, it's also prosecuted on a regular basis. Overall, the German regime is very strict and also very complex, which makes it not very easy to follow the rules precisely. So there is no room to hope that all goes well. And of course, you will raise the question, is this all theory? No, it's not. These cases are actually going to the courts. However, there is certain recent legislation which gives some hope that things become better from the point of view of the managing director. Mainly the recently enacted Code on Stabilization and Restructuring of Companies provides for legal framework for out-of-court restructurings. These procedures are not completely out of court, but the idea is to give a framework for the company and the management to try something with only little formalities. This is of much help in order to reduce the risk of restructuring efforts and to avoid personal liability in this connection. I mentioned already the payments which are often made at the last stage before filing for insolvency. There is new legislation on interdiction of such payments. I'm referring to the examples I've given, like payment of service companies or provider of supply, which are made in the last phase of the company before insolvency would have to be filed. So the new rules are more generous and more clear, which is a good message, and the narrow limits of previous case law shall be removed. However, they are not as clear as one could wish for, and it remains to be seen what the courts will make out of it, in particular of these questions which are not stipulated for in detail. Also, I would like to draw your attention to a recent court decision concerning startup companies, which make life easier for directors of startup companies. By definition, startup companies make no profits and have not a lot of assets. So under normal rules, they are easily on the verge of insolvency. But also usually a solid investor is involved. And as the case might be, this investor is not contractually bound to make additional payments, but has done so in the past, in particular if the company is developing well. So the director will face the problem. Can he rely on the investor who always has contributed cash when needed, although there is no legally binding contract with that investor? And in this recent judgment of July last year, the court decided, yes, the director may rely on such an investor when doing his positive going concern prognosis, which Christiane explained in her part. And the managing director may, for these purposes, rely on the investor and may, in his planning, plan in such payments which are not which do not have a contractual basis and only where the word of the investor counts. So what's the takeaway message for the German situation? As stated, it's a complex matter. There's a lot of liability and a lot of traps. So be prepared. And I'm saying this because recently we discover very solid companies struggling with questions they have never dreamt of. Like they are facing the situation of dramatically increases in energy costs. They are facing the well-known problems with the supply chain. And only very few had anticipated such problems. I'm saying this because even if you're looking at very well-established and good-running companies, you can be taken by surprise in these challenging times. And therefore, it's vital to be prepared, to have done your homework, meaning your documentation on your numbers, that you always can prove at which point in time how the financials looked like and how you made your decisions based on this. You also should double check them and be able to provide these numbers later, meaning in case insolvency occurs and the question of liability pops up. You are not in the driver's seat anymore. Probably the administrator has all the numbers. He can check for every point in time how the prospects of the company were, and you will be faced with the problem of defending yourself against such claims without having something in your hands. And this is something you should be prepared for. That's all from my part. Thank you for listening, and I will hand over to my Italian colleague Pierluigi to tell you about the situation in Italy.
The scope of my speeches, I believe that I was in mute, so sorry for this, for the problem. I was saying that if somebody some question can make the question in the Q&A part of the presentation. We will try to answer to the question at the end of all the speeches, and or if not possible, if the answer is too long, we can send you an email. So the scope of my speech is, of course, to represent you which are the directors' liability in distressed company under an Italian legal standpoint, and I will try to answer to the same question that my German and French colleagues have answered or will answer after that. So, what is insolvency in the Italian legal system? So we have a very old definition in the current bankruptcy law that states that a debtor is insolvent when he is no longer able to meet his obligation regularly. So very general, not easy to identify. And the law says that this situation can be manifested, can be shown by some defaults. The possibility to pay is the overdue invoices or other external facts. Then I will very shortly describe what the Italian case law considered as indicator of a situation of insolvency. But before to swift to this point, I would also to highlight which is what the new Italian laws provide on this matter, because the Italian legislator enacted in 2019 a new bankruptcy law called Code of Business Crisis and Insolvency that was supposed to enter into force in 2020, but this entry into force was delayed because of the pandemic situation, and was several times postponed, and now is supposed to enter into force in 2023. However, it's important to also to anticipate what the future law will say, because some provision of this new law has been already incorporated in the Italian Civil Code, and as we will see, and they are already in force. The new Italian bankruptcy law switched the focus of the legislation no more or not only in the insolvency, which the new law defined as the old law, such as the situation where the debtor is no longer able to meet his obligation regularly, but they introduce also a definition of crisis, and the focus of the new law is in the crisis. So, because is to avoid, as far as possible, of course, that the company, that an enterprise arrive to a insolvency liquidation, but react to a financial distress situation before the insolvency, and so to avoid this kind of situation. What is crisis? Crisis is an imbalance, an economic and financial imbalance, which make insolvency of the debtor likely. And in particular, and this definition is more strict, in particular when the prospective cash flow are already can be already assessed as inadequate for the purpose to meet the planned obligation. So in this case, as we will see, the director, the entrepreneur, has already an obligation to react and to start to file for procedure for overcome the financial crisis before to apply for bankruptcy. So, as I said, when there is from a practical point of view when there is an insolvency. An insolvency, according to the Italian case law, here we have a very important decision of the Italian Supreme Court made in 2003, when there is a loss of liquidity and of credit condition that prevent the company to have the financial resources, the cash, to pay its obligation. What I want to stress is that it's not just a problem of liquidity, because the company can always have the possibility to have credit worthiness, because maybe somebody give to the bank or to the financial institution sufficient guarantees in order to continue the flow of financing from the bank, or there are shareholders that continue to inject in the company the money and the cash required to go ahead in the activity. So in this case, we cannot say that there is an insolvency of the company. So it's a situation very similar to what my German colleagues represented according to this last decision. Insofar as there is the commitment of the shareholder to inject money, or to other partner, other bank or financial institution to inject money of the company, so we cannot say that there is an insolvency situation. Then we have a very practical index about insolvency situation, which is of course the stop of payments or payments made by normal means. So, for example, payments made through barter, through giving back goods, products of the company instead of cash, enforcement of bills against the company, against the debtor, or attachment of his asset, withdrawal bank financing, and other important index of a situation of insolvency is what arises from the financial data of the company. It's important to stress that in Italy, but I believe that is an issue also in other legal systems in other countries, the directors have an obligation to put a company into liquidation in case of a reduction of the equity capital below the legal minimum. The normal cases is when, for example, the company has lost due to the negative result to the losses, has lost its entire equity capital. What I want to stress is that the directors has a continuity obligation to check if the equity capital is above or below the legal minimum. It's not just once a year when the directors draft the financial statement that they have the obligation to check if the equity capital is still existing or not. But they should check this situation during all the fiscal year. So in order to see, and if there is a problem, ask to the shareholders to inject money, or otherwise the obligation is to put the company into liquidation. Different from the German system, in Italy there is no formal obligation of debtor to file for bankruptcy. In German, our colleagues say that there are specific time when within which the director have to file for bankruptcy, have to file for insolvency, have to file for some kind of composition with creditors procedure. In Italy, there is no formal obligation. So the law, and also the new law, does not state a term for this. But, however, the director should take into consideration that if they delay the application for bankruptcy, and this delay cause an increase in the financial disarray, in the financial losses of the company, they commit a criminal offense and they can prosecute by the public prosecutor. This is a criminal offense called in Italian bancarotta semplice. The directors and auditors as well as can also be liable on the civil point of view. According to this provision of the Italian Civil Code, which is the new provision I mentioned before, which was enacted in 2019, according to which all the enterprise, individual enterprise or company, and when we speak about company, we speak about an obligation of the directors, of course, as the duty to set up an organizational, administrative, and accounting structure which allow the entrepreneur to immediately detect or to timely detect a case of business crisis and the loss of business continuity. So, as I said before, if there is a problem of loss of the capital, the company has to have a structure that allows the director to immediately detect that there is this problem. And they have to take action without delay in order to implement one of the instruments provided by the law in order to overcome the financial crisis, the business crisis, and recovering in this way the business continuity. So there is no fixed term, defined term to file for insolvency procedure or to file with other kind of composition of creditor procedure, but the law provides that without delay, the director have to do it. Maybe for reason of time, we can shift the slide and see what happens if the director does not comply with this duty. First of all, in the Italian legal system, the legal ground for directors' liability, directors and statutory auditors' liability, is on potential 4 legal provisions. One is the liability of the director vis-à-vis the company for damages caused by the mismanagement of the company. Then there is the liability of vis-à-vis of the director vis-à-vis the company creditors, because the company has not, due to the mismanagement of the creditors, sorry, the mismanagement of the company, the director has no more the possibility to pay his obligation. Then we have a very special liability, which is very important in the multinational group, which arise out of the exercise of direction and coordination activities in other companies. This is the liability on the director of a subsidiary and the director as well of the parent company, in case the subsidiary is obliged to take a decision to cause damages to the creditors of the company or to other third parties. Then we have a residual form of liability of the director and auditors vis-à-vis individual shareholders of third parties. What is important to say is that the receiver, the bankruptcy administrator, is entitled to start a legal proceeding against the director and auditors on the ground on the first 3 types of liability. And in case of bankruptcy, the bankruptcy receiver is the sole party entitled to start a legal action on this ground. And I have to say that it is quite common in Italy that in case of bankruptcy of a company, the bankruptcy receiver brought a legal action, sue the directors and auditors in order to recover money to pay the creditors. It happens very often, and this is the reason because directors and auditors are in some way afraid to start a bankruptcy procedure, to ask for bankruptcy, because they fear that they are concerned that after that the receiver will take an action against them. For reason of time, I shift the slide where these liability types of liability are described in details, but maybe you can read. And I want just to give you some practical hints. When the liability of the director arises, this not depends on the negative from the simple fact that there is a negative result of the company. Mismanagement of the company does not mean that a contract, a business decision has not given the result that were the positive result that were expected. What is a negative, what is considered as a mismanagement is when the business decision was taken by the directors without the required care and diligence, without preventive check and information. For example, just to give you a very easy example, it happens sometimes that a subsidiary company, which has a lot of cash, is required by the parent company to make a loan to other company with the same group because of the other company, the sister company, has a cash problem. If the director of the subsidiary of the lender does not perform a check on the capability of the borrower to repay back the loan, or to pay back in normal fair market interest on the loan, they can be liable, of course, because they are not making a fair market transaction without any kind of preventive check and without the normal care they will use in case the borrower is not a company belonging to the same group. Other kind of when director's liability arises is the failure to identify financial losses, and this according at least to Italian bankruptcy receiver happens very often. For example, the Italian receiver can argue that the director did not detect that there was an overestimate assets in the company, and they did not detect for this reason that there was a loss that obliged them to put the company into liquidation. For example, the financial statements apparently are positive, have a positive result, because the value of the participation in the company or the value of the inventory is quite high. But if a fair evaluation, a fair assessment of the value of the participation of the inventory could lead to the company to have a negative result. And in this case, the obligation to put the company into liquidation can be very earlier in time. I follow cases in which the director was accused by the bankruptcy receiver. They did not detect that the company had lost its capital 5-6 years before the date of the bankruptcy. And which are the consequences of this? The consequences of this are indicated in this section of the Italian Civil Code. So, first of all, in case of occurrence of the loss of the capital or any other case of liquidation, the director should stop the normal business activity, but they have to limit the management of the company to the sole purpose of preserving the value of the company asset. If they don't do it, they are personally and jointly liable for that damage for the continuation of the activity. What I want to stress is that this depends not on the declaration of the liquidation, but from the fact that there was a reason, a just cause to put the company into liquidation. And in this case, the amount of the damages can be very high because the director will be obliged to pay the difference between the net asset of the company at the time when the cause of liquidation occurred and the value of the net asset of the company at the opening of the insolvency proceeding, which can be a very huge amount of money. So, at the end of my speech, what I would like to say is that crisis prevention is no more an option. In order to avoid dangerous consequences, the director should take care and detect as soon as possible if there is a financial crisis and without delay, as the law says, start to approach any kind of composition with creditor procedure in order to avoid consequences. Thank you. I wonder if our French colleague is online now or not, but I don't believe so. So maybe Gianluca, what we can do? I give you the floor and tell us what we can do.
Okay, thank you very much. Thank you very much, Pierluigi. We know from the assistance room that there are some questions. So we are glad to answer the question. Maybe that we managed to do it today, or in case we can do that by email. So since we still have 10 minutes, so I suggest I kindly ask you to put the email under the question so that we can revert to you after the webinar. At the moment, since we have some technical problem to connect Sarah, we try to do it this way. So we connect Sarah only the vocal, and I show the slide of the Sarah, and I hope that Sarah helps me to go ahead with the presentation. Sarah, you can go ahead. Can you hear me? You can go ahead if you want.
I can hear you. Firstly, I'd like to apologise to everyone for the IT difficulties. I know it's not ideal to do it like this, but unfortunately, that's the best we can do today.
Okay, just a second, Sarah. Go when you want to go ahead. You just say go ahead. Go on. Go ahead.
No problem. So if you could put it on the first slide for the French, what and when is insolvency? So in France, I think we've already touched on it during the webinar. Obviously, there's the debate between cash or balance sheet insolvency. In France, it's cash insolvency that's used to determine when a debtor company is, or a debtor in general, is insolvent or not. It's the French Commercial Code that defines the state of cash insolvency in France. The direct translation of that is a debtor who is unable to meet current liabilities with his available assets. And then this characterizes that the debtor is in suspension of payment. In our insolvency procedures only treat cash insolvency. Balance sheet insolvency is treated differently, putting obligations to shareholders to reinforce equity, for example. And also that can also be used as a sign to characterize late action by directors to treat a delicate financial situation of a company, and therefore can contribute to director liability if there is a case for that. If we dig a little into what we mean by current liabilities and available assets, current liabilities, it covers the debts of legally or contractually fallen due. So they've come to their legal or contractual terms, and it's important to distinguish in French law between official and unofficial moratorium. Just because the creditor has not contacted us several times to be paid, it doesn't mean that you've got an official moratorium. If obviously there's an official moratorium on the debt, that pushes back the legal term of an obligation, and so we can take that out of the current liabilities math when we're calculating if we are cash insolvent or not. For the current assets, it's for the available assets, it's basically the cash mainly. I mean, we can also have in that the credit reserve that a bank might accord, and we could also sometimes include in that maybe some payments that are sure to be paid and will arrive in the next few days. But it's quite a restrictive notion. And so once we've determined the two matters of current liabilities and available assets, it's a mathematical equation. If the current liabilities exceed the available assets, you are in suspension of payments in France, in French law, and you're considered cash insolvent. If we could go to the next slide. So once we've seen that we are cash insolvent, the next step is when to file for insolvency and what delay. Could you go to the next slide, Luca, if possible? It's slide number 4. I don't know. Maybe I'm not on time with the presentation. So if we're on slide number 4, you should have the article 631-4 of the French Commercial Code in front of you, and that tells us that in France, a debtor company that has that realizes that it's cash insolvent from that date has a 45-day delay from the moment the company has become cash insolvent to go and see the commercial court. It's important to note that in French law, the framework around insolvency is rescue-based and considered pro-debtor in the sense that it doesn't treat creditors very well, but it's historically not really considered pro-debtor because there wasn't a lot of possibility for directors to rebound. So many reforms over the years have aimed to change this image and even the legal basis of the framework, to encourage directors to use the framework in order to treat difficult situations. There's two main types in French law, so you've got them on the side. First type is the preventive framework. So that's a mandat d'oeuvre ou une conciliation in French. The preventive frameworks, they're confidential, they don't limit director powers, and they're considered what we'd call practically out of court. There's just the president of the commercial court that knows about it, but it's completely confidential otherwise. And the court doesn't really have a massive role in these procedures at all, only eventually to sanction an eventual protocol if we find an agreement, and it's not even necessary technically. The judicial block, so the collective insolvency proceedings, they are public, the court oversees them, and the director loses the possibility to exercise his powers and prerogatives fully. In bold, I've highlighted the two that are concerned with our 45-day delay. The other two, the mandat d'oeuvre and the sauvegarde, the safeguard proceedings, you cannot be cash insolvent to open those. However, you can open a conciliation proceeding if you are cash insolvent, but you have only been cash insolvent for less than 45 days. And the redressment procedure that is on the bottom, so that's kind of like an administration proceeding. The debtor must be cash insolvent to open, and normally should file within 45 days. In practice, a lot of the time, the directors are over the 45 delay limit. The choice between two procedures, you could ask ourselves that, what's the choice? How do I pick which procedure? It depends on lots of things. Business model of the company, the financial situation of the company, the relationship they have with their providers, the debt structure. And so that's something that you need to see with a professional counsel to guide you in that choice. For the administration proceeding, I just something that can influence director liability. Before the administrative proceeding is opened, there's a period called a suspect period. So from the moment the debtor company is cash insolvent until the proceeding is open, we're in a suspect period. And during this time, a director must not do anything detrimental to creditors or to the insolvency estate. You can't degrade the insolvency estate. Otherwise, it is a basis to hold the director liable for a certain number of things. We're going to go to the next slide, if possible. So what might happen to directors and auditors? What liability types of liability exist in France, and how do we apply them in practice? We're going to start by looking at the little flow chart on the right. Talk about the conditions. As I mentioned, most of the procedures are rescue-based. So if we rescue the company, often there's not really grounds for the director liability to be put on the table, because if we rescued it, we've treated the difficulty properly and that we caught it in time. So we're often in a liquidation, like a liquidative context, so a liquidation context. When we talk about directors, it can be the legal director or the de facto director, so it's important to remember that. And we're also talking about private persons, so either companies or it can also be physical people, but we're not talking about public or parapublic entities. On the left, we've got 6 little blocks. You'll notice that the last one is in grey. That's because that isn't a specific bankruptcy liability. It's all kinds of obligations that a director must respect in any case. Accountancy rules, proper asset rules, etc. The other 5 blocks, we'll just quickly go through them. The first one is a financial liability. A director may be liable to cover the shortfall of assets and to cover all liabilities under certain conditions, notably if their behaviour might have contributed to the said shortfall of assets, but purely financial. On the civil prosecution basis, the insolvency practitioner might seek a ban for a person to hold a management position or a director's office for a certain amount of time if they think that their behaviour was merits such a sanction. The bankruptcy prosecution is a criminal liability. It's rare, to be honest, and it's characterised by certain reprehensible behaviour, and there's an intentional element that's required. So often, for example, purposely having done things in order to seek to delay insolvency proceedings. And the fourth are other criminal prosecutions. So in the French Commercial Code, there's, for example, if a director doesn't properly comply to his obligations during bankruptcy proceedings, then the director can be sanctioned for that. The last one is slightly different. The extension of insolvency proceedings, it's not really a type of director liability as such, but it is something that can highly affect the director's personal state. If the insolvency practitioner considers that there's been abnormal relationship between a director and a company, or even several companies, the insolvency practitioner can decide to extend an insolvency proceeding, to another person, another legal person. So that can be a physical person or a company. And in that case, they englobe that person's estate in the administration proceeding. So that means that a director's personal estate could be at risk. So even though it's not technically a type of liability, it's pretty much the same kind of sanction as the shortfall of assets. It's a financial sanction that can be imputed to a director. In France, it's the insolvency practitioner, the attorney general, or the creditors that can initiate these proceedings in function of different types of liability. It's the different people and the different conditions for people to act. But as I said, and I'll finish with that before we go on to the last message to take. The public policy in France recently is to encourage the use of these procedures. So to avoid direct liquidation, we encourage them to come and use these preventive procedures. If, in order to do so, directors must feel safe using these procedures. They can't think every time I'm going to open an insolvency proceeding, my liability is going to be put on the table. I'm going to be sued. I'm going to be held liable for shortfall of assets. I'm going to be held liable for any kind of act that I've done. So it's very important that directors feel safe using these procedures. Otherwise, they will not use them, and will end up in direct liquidation. To illustrate this as well, the interest of using them for direct liability is that often, if you open preventive frameworks and then unfortunately do finish in liquidation proceedings, often the fact that you have even used a preventive framework can influence an insolvency practitioner to say, well, maybe the director did not do everything right, but they did try and save the business in time. They tried to act in time. And in that case, I am not going to sue the director. I'm not going to put the question of his liability on the table. If we could just pass to the last slide, and I'll finish with that. Is seeing what I've just said, the message in France is prevention is better than cure. Not only for direct liability, but also the statistics in France show it. The preventive framework, they have a success rate, a national success rate of about 80%. So basically 4 out of 5 companies that use these frameworks, they will find a solution to their difficulties. If we go on to the other 2 judicial types, the collective insolvency proceedings, the safeguard proceedings, they have about between a 30 and 50% success rate, and the administration proceedings, the redressement judiciaire, we're nearer to 20%. It's about between 17 and 20%. So it's the opposite of the preventive framework. In the preventive framework, 4 out of 5 companies will find a solution to their difficulties. In the administration proceedings, only 1 out of 5 will find a solution to their difficulties and not end up in liquidation. So that really is important in French restructuring, is to try and use the framework that is put at the disposition of directors and use it as a management tool and not just as a last resort. Again, I'm very sorry for the technical difficulties, and I'll give the word back to Gian and Luca, but we'll see if there's any questions. Thank you very much for listening.
Okay, sorry, I was talking in mute. Very sorry. Okay, thank you, Sarah. So I think we have some time limits. It's a good pleasure to start with this first thematic webinar, and we hope to go ahead with the long series. And I tell you again that if you have some question, you can please write the email address in the writing chat on your screen, and we will be very glad to answer. I know that the subject is a little bit complicated, and the comparison between the countries is very complicated, but we hope that it is interesting also. We hope so. And so thank you very much, and we hope to meet you the next webinar.